When you're involved in a car accident, the impact often goes beyond physical injuries or vehicle repairs. The emotional trauma, mental stress, and lasting discomfort can be just as damaging, and under the law, you may be entitled to compensation for what's known as pain and suffering. In this article, we'll break down what pain and suffering really means in a car accident lawsuit, how it's calculated, and why documenting your experience is critical, especially if you're considering legal action. What does pain and suffering actually mean? Pain and suffering refers to the non-economic damages you experience after an accident. This includes the physical discomfort and emotional distress that affect your daily life, often long after the crash is over. This can include ongoing physical pain or disability, emotional distress, anxiety or depression, post-traumatic stress disorder, PTSD, insomnia or sleep disorders, loss of enjoyment of life, long-term inconvenience due to therapy or injury. These effects are just as real as a broken bone or a totaled vehicle, but harder to calculate without legal guidance. Examples of pain and suffering. If you were rear-ended at a stoplight and suffered whiplash, you might struggle with headaches, sleepless nights, mood swings, and physical therapy sessions. You may miss out on time with your children, work, or even just peace of mind. All of that, physical and emotional, falls under pain and suffering. How do insurance companies calculate it? There are two common methods used by insurers and courts to determine compensation. Multiplier method. Your medical expenses are multiplied by a factor, typically between 1.5 and 5, depending on the severity and lasting impact of your injuries. Per diem method. A daily dollar amount is assigned to your pain and suffering, and then multiplied by the number of days you've endured the hardship. Every case is different, and how well you document your experience can significantly impact the outcome. Why documentation? Is key to prove the emotional and physical toll of your accident. It's important to keep a daily log or journal of your pain, mood, and activity limitations. Save all medical records, prescriptions, and therapy notes. Track missed work, family events, or activities. Ask loved ones or coworkers to provide supporting statements. These records help paint a clear picture of how the accident has disrupted your life. Can you claim pain and suffering without physical injury? Yes, emotional trauma can qualify as pain and suffering even without visible injuries, though these cases are stronger when supported by medical or psychological documentation. Be proactive, not just reactive. At DMV Testmaster, we believe in being proactive, not just reactive. Our platform is designed to help prevent accidents through education, skill building, and smart driving decisions. Whether you're preparing for your CDL, teen permit, or hazmat endorsement, our tools empower you to drive safely and confidently. But when accidents do happen, it's vital to understand your legal rights, especially when pain and suffering are involved. That's why DMV Testmaster partners with super lawyers to ensure drivers like you can access trustworthy, experienced legal help when it matters most. If we haven't partnered with a firm in your area yet, reach out to us directly. We'll connect you with a top-rated law firm with a strong record of representing accident victims. Final thought. Pain and suffering may not be visible, but it's real. And it matters. If you've been in a car accident, you don't have to face the emotional toll alone. With the right guidance and support, you can pursue the compensation you deserve. And remember, the best protection starts before the accident. Stay sharp, stay informed, and drive smart with DMV Testmaster, your trusted partner in defensive driving and safer roads.